Welcome and thank you for joining us for part 3 of our 4-part on-demand learning series focused on estate planning. My name is Becky Wiest and I am an instructor and research specialist at Howard County Library System. We are excited to partner with King Hall LLC, a law firm located in Ellicott City, Maryland, to provide you with this educational resource. Today, two of King Hall's associate attorneys, Kelly Renaud and Michael Dubé, will discuss trusts.
Thank you, Becky. Most people think of an estate plan as simply planning for the distribution of your assets after you have passed through the creation of a will. A well-drafted plan consists of more than a will and should also include an advance medical directive, power of attorney, and in some situations, a trust. The goal is to have a plan that is usable, flexible, and meets your needs for a long time to come. Together, this set of documents allows you to safeguard your goals, protect your values, and avoid or at least delay guardianship.
In this series, Kelly and I will discuss many of the estate planning options. While we have already reviewed the will-based and trust-based estate plans, trusts deserve additional attention as there are so many different types. Today, we will explore at least 8 major categories of trusts. First, Kelly, will you explain the components of every trust and why someone would even want to create one to begin with?
Of course. So a trust, as we've mentioned in other episodes in this series, is a legal relationship among 3 entities. There is a grantor, a trustee, and a beneficiary. A grantor grants legal title to property to the trustee. The trustee has a duty to hold that property for the benefit of a beneficiary. Thus, there are at least 3 main roles. Sometimes these roles are held by the same person. Other times they may be held by many different people or even shared. Each role can be shared by more than one person. So why would anyone want to create a trust? We've already touched on or explained examples in other episodes of this series. And what we've mentioned is to avoid probate, to protect the grantor or the beneficiary's privacy, to plan for minors or incapacity, to protect against creditors, and to minimize taxes. In fact, minimizing taxes is something that we will explore further in this episode.
So there are 4 main types of trusts. The first is called the living trust or inter vivos trust. This trust is created during the grantor's lifetime when the grantor wishes to benefit from the trust's assets and property while they are alive, but ultimately pass them to a beneficiary upon their death. Handling property this way usually allows one to avoid probate. A living trust can be revocable or irrevocable. The second is a testamentary trust. We discussed testamentary trust during our will-based estate planning video. This type of trust is irrevocable. That is, it cannot be changed or altered and is created through a will itself. The third is called a revocable trust. Similar to the living trust, a revocable trust is created during the grantor's lifetime. This was discussed during the trust-based estate planning video. The grantor can change or terminate the revocable trust. In this trust, the grantor, trustee, and beneficiary are often the same person, and these trusts are frequently used to pass assets outside of probate. Upon the death of all the grantors, the trust becomes irrevocable. The successor trustee steps in, and the beneficiaries change. The fourth is called an irrevocable trust. We also touched on irrevocable trusts during our trust-based estate planning video. An irrevocable trust is created while living, but importantly, it cannot be changed during the grantor's lifetime or revoked after the grantor's death. This type of trust results in the grantor being removed from having any control or influence over the trust property, which can result in tax benefits. Kelly, would you like to discuss 5 additional but less common types of trusts?
Yes. So you might have heard the term special needs trust bantered about and wondered what that is exactly. This often occurs when there is an individual with access to assets which may disqualify him or her from receiving governmental disability benefits. To allow that person to benefit from the additional assets and receive the disability benefits, a special needs trust may be established. The disabled individual is the beneficiary of that trust, but may only receive distributions under certain circumstances based on an ascertainable standard. Very often, the HEMS standard is used. Distributions may be made for the disabled person's health, education, maintenance, and support. If distributions are made for any of these four purposes, which can be broadly interpreted, then they will not interfere with that person's ability to receive government benefits as well. Another type of trust you may have heard about is the charitable trust. This trust is irrevocable. The estate tax, just like income tax, allows for charitable deductions. Hence, if you gift assets to a charity through a trust, those assets may avoid estate tax. If you establish a charitable remainder trust, this allows for an annual payment to a non-charitable party such as yourself, with the remainder of those assets passing to the charity at the end of the term of the trust or at your death. The reverse can also be established. That is, you can have a charitable trust that distributes annual payments to your charitable entity, with the remainder instead passing back to the grantor or a beneficiary. These trusts I mentioned can be set up for a specific term. For example, 15 years. So during those 15 years, that annual payment or distribution will take place. And at the end of those 15 years, the trust terminates and whatever assets remain are then distributed per the instructions of the trust. A non-charitable trust is just as it sounds. It's for a non-charitable purpose. This kind of trust is irrevocable. It does not have any human beneficiaries. It has a purpose that it is meant to advance. This purpose has to be reasonable and attainable. Examples of non-charitable trusts are those that are established for a pet, maybe to maintain a gravesite, or to help maintain a collection, an art collection. At the end of the trust's term, could be 10 years, it could be 25 years, the assets are then distributed according to the terms of the trust. Now, in the case of a non-charitable trust set up to care for a pet, the trust might terminate when that pet passes. The last two types of trust that we'll touch on are identified here by acronyms. The first is an ILIT. That is an irrevocable life insurance trust. This is designed specifically to hold life insurance proceeds. When the beneficiary designation on the life insurance policy is the trust, then when you pass, or rather the policyholder passes, the proceeds from that life insurance policy is paid into the trust, and the trustee manages them for the benefit of your beneficiaries. This helps avoid estate taxes on life insurance payouts. The last type is a Q-tip trust. This is a qualified terminable interest property trust. It allows one spouse to gift property to the other spouse. In this way, federal gift tax is avoided. There is an annual exclusion for gifts. However, if you give more than it's subject to tax, a Q-tip can help with this. This ensures that the income from the trust is paid to the surviving spouse, but the remaining assets in that original trust will be held until the surviving spouse passes, and then the rest is paid to the beneficiaries. Now, you may think, what about the marital and bypass trust, which we discussed in the trust-based estate plan? It seems to perform a similar service. A well or a robust trust document will often include both types. And we refer to this as a belt and suspenders approach. It's simply covering all of your bases. One common thread that you may have noticed is that many of these trusts are irrevocable, which is how they avoid estate tax. It is a way to distance yourself as grantor from these assets. If you no longer have free control over them, they are no longer part of your taxable estate.
So to wrap this up, we'd recommend that whatever planning documents you have, safeguard the originals and share your intentions with those that need to know. Otherwise, you are inviting discord and potentially trust interpretation litigation in the circuit court.
All right, thanks so much, Kelly and Michael. We have a few questions. First up, are any other people involved in a trust besides the grantor, trustee, and beneficiary?
So as with all legal questions, and perhaps unfortunately, the answer is that it depends. There can always be other individuals or entities involved when a trust is in play. Those people and entities could be a trust protector, who is usually there to appoint a successor trustee when there is no named successor trustee left. A trust protector would also help avoid court involvement, which would be, expensive. There could also be a trust company who would stand in for an individual. There could also be third parties such as a financial or an investment advisor or a doctor or other mental health professional if there's an issue of capacity at play. And ultimately, the court could be involved, though one would hope to avoid its involvement. The circuit court would be responsible for adjudicating any trust-related issues.
Right, our next question, how do I fund my trust?
Well, Michael already alluded to one example of when somebody would like to put their real property in trust. Anything with a title, such as real property, a house, land, or a banking account, needs to be retitled or in the case of a house, redeeded in the name of the trust. So that deed would need to be redrafted and re-recorded with land records before the house is in trust. The bank account would need to be opened in the name of the trust, and then those financial assets would have to be transferred into that bank account for the money or those assets to be considered in trust. A trust can also be listed as a beneficiary on accounts such as retirement accounts, life insurance policies. And another example is personal property. Say you want to hold your jewelry in trust. This can be done through an assignment of personal property, where a document is included in your entire trust document where you would list all the personal property that you want to be or that you assign to the trust. So depending on what it is you want to have in your trust, there are different ways that different actions you need to take to make that happen.
And our last question, how long does a trust last?
So a trust can last a very long time. In fact, it can last across generations. But generally, trusts end as soon as the first of four things happen. The first being that the beneficiary passes away. The second would be that the trust terminates based off of language in the trust itself. For example, if the trust has served its purpose already, then it would terminate. Or if there's been a judicial cause to terminate the trust, for example, an extreme breach of fiduciary duty by the trustee. The trustee is also allowed to terminate a trust under the Maryland Trust Act if there's a low value of assets in the trust, which effectively renders the trust, void at that point.
We hope that you found this presentation helpful. We actually have 3 others in this series: the will-based estate plan, trust-based estate plan, and how to avoid or at least delay guardianship. Of course, you can always contact us at our office for additional questions and assistance.